SJC-11930, Commonwealth v. Matteo, Trotto.
Okay. Mr. Shaw.
Chief Justice Budd, and may it please the court, my name is Robert Shaw. I'm privileged to appear today on behalf of Matteo Trotto. My intention this morning is to begin with the felony murder sufficiency issues and then to reach as many additional issues as I can, starting with those that are most closely related to sufficiency. As a basic backdrop, the Commonwealth concedes that the first-degree felony murder judgment in this case cannot stand. And so the question before the court is whether there is legally sufficient evidence of second-degree felony murder with non-aggravated kidnapping as the predicate. If the evidence is deemed sufficient by the court, the issue becomes whether Mr. Trotto receives a new trial or, as the Commonwealth desires, a reduction to second-degree felony murder. Now, with respect to the issue of sufficiency, there are multiple reasons why the evidence in this case does not sustain a felony murder judgment, and this morning I will focus on two. First, there is simply no evidence in this case that establishes a kidnapping. There's no mystery about how Kevin Harkins left SUNY's pub on February 15th, 1994. It was observed by 4 witnesses. 3 of those witnesses.
Could you address the Carlo statement, please, and how that relates to sufficiency?
Yes, well, Carlo, first off, we think there are a number of problems as indicated in the brief.
Okay, well, assume, just for the sake of my question, you can maybe get to it if you want later on, that Carlo's, the judge's ruling on feigning memory loss was invalid. You know, assume that was a proper ruling for now, for these purposes. So say we disagree with you on that and Carlo's statement properly was admitted for its substantive purposes. How does that relate to your sufficiency argument on non-aggravated felon kidnapping, please?
Well, Carlo's statement does not establish that there was a kidnapping. Even if we accept Carlo's statement, what it says is that Harkins was picked up from SUNY's, and that's all it says. So, you know, and the issue here—
They held a gun on him in a car.
Well, Carlo's statement doesn't actually say that. What Carlo's statement says is that they picked him up from SUNY's, so it doesn't establish a kidnapping at SUNY's. And that is the only conduct in this case that could have comprised a kidnapping, is what happened at SUNY's. And then it says that there was an accidental discharge that shot Harkins. But that's all his statement
There was a
says.
beef. He was picked up at SUNY's. They started beating him up. They had a gun out and it went off. No,
Your Honor. No, Your Honor. And that's a very important distinction. You're confusing this case and the evidence in this case with the evidence in the Samia and Fredette cases.
I'm reading from the grand jury. He said that the defendant told him he had a beef with Harkins for setting up Fredette, picked him up at SUNY's, started to beat him up, but the gun went off accidentally and he shot Mr. Harkins before he wanted to. Was that the evidence?
My recollection, I do not recall Carlos saying anything about beating him up. And I don't believe that came in at the trial. I think this— no.
I'll look at it more carefully if you.
Okay, but
we're going to look at it anyway. But please.
Yeah,
continue.
but so in any event, the point being is that what this concerns is whether there is a kidnapping. And the fact is that the evidence doesn't establish a kidnapping. The only judgment here is a felony murder judgment.
What about all the evidence about, you know, leaving the Lucky Celtics jacket behind and the cigarettes and the like?
Your Honor, the fact is that when they left SUNY's, if we assume that it was Mr. Trotto who motioned him, no one observed force, no one observed threats, no one observed a weapon of any kind. There was no confinement, no imprisonment, no restraint, no lack of consent. None of this was observed by any of these witnesses.
Can you forcibly confine someone if you pick them up and then take them for a ride and it gets violent and they're still in the vehicle? Is that a kidnapping?
Your Honor, again, I'm somewhat confused by the line of questioning because in this case, they're leaving SUNY's, but there is no evidence of what happens in a car after they leave SUNY's, apart from Carlo's statement that there was an accidental discharge of a firearm, if we accept those as that evidence is coming in. There is no evidence in this case about what happened after they left SUNY's. And I think it's important to note that the government's case here, their focus during trial and their theory is that there is a kidnapping that occurs at SUNY's. That is where the kidnapping occurs. Any notion that he was detained later, we don't know what happened in the car later. And it's important not to confuse that with the Samia and Fredette cases.
Could you answer my question? Can you have a kidnapping if I ask you, hey, let's go for a ride and let's go around Boston, and then I pull out a gun and things get ugly after that and you're confined in the car? That could be a kidnapping, correct?
Oh, sure. I think that could be a kidnapping. I think that's why there was perhaps sufficient evidence of a kidnapping in the Samia and Fredette cases, because they brought in different evidence about what happened in that car. In this case, we don't have evidence of what happened in that car.
Okay. Well, I'll ask Ms. Lazar the same questions, and I take you at your word as far as the evidence goes. Please continue.
Yeah. So the other thing is that if we assume for purposes of discussion that the elements for a kidnapping were met in this case, there was insufficient evidence that it was committed with conscious disregard for the risk to human life. And again, the only evidence presented in this case that could have comprised a kidnapping was what happened at SUNY's. And there's nothing that happened at SUNY's that would have met the element of conscious disregard for the risk to human life. And I think it's important.
So you keep on saying that the kidnapping had to happen at SUNY's. So if the kidnapping happens at SUNY's, but then someone produces a gun in the vehicle, isn't that a conscious disregard of human life to have a gun waved at somebody?
Well, I think the problem in this, a gun waved at somebody, I don't recall any evidence of waving a gun at anybody.
The Carlo statement, the gun just goes off and then he's dead. So isn't that having a gun a loaded gun in a vehicle and taking the gun out, wouldn't you say that's conscious disregard of human life?
Well, in my view, Your Honor, of the evidence, I don't think there is sufficient information about what happened in that car. We don't know what happened in that car, or what evidence led to a gun's accidental discharge, in the words of Anthony Carlo.
Is there any import to the jury's decision that there was an aggravated kidnapping?
Well, I think the important aspect of that is that the aggravated kidnapping was grounded in the assertion that when Trotto walked out in what appeared to be a voluntary way, according to all observers, out of SUNY's, he had a gun. And that's an unfounded assumption that simply can't be sustained on this evidence. And so I think that's what the jury focused on, and that's why they found it. And I think that can't be sustained.
You're right. Where did they get that evidence, Mr. Shaw?
Well, I think they probably got it from, it was what the prosecutor asserted, that when they left SUNY's, Harkins left SUNY's because there was a gun.
Okay. Was an objection at trial by a very competent lawyer that misstated the evidence?
Well, I think that he was arguing that there wasn't sufficient evidence that there was a kidnapping and that there wasn't force. And I think that what the government did is they wanted to say there is force. He probably had a gun when he walked out, and that's why Harkins went out, notwithstanding the fact that it didn't look like there was any explicit force by Trotto.
So you're saying that's pure speculation?
Well, what's the basis that he used a gun to get Harkins out of SUNY's? I just don't think that it's there in the evidence. And whatever happened later in the car, we don't know when that happened. I mean, how many hours was it later? I mean, they were stopped 4 hours later. I mean, there's just a real gap in the evidence in terms of what actually happened and when it happened. The evidence just doesn't really address that. And on the issue of conscious disregard, I think contrary to the Commonwealth's assertions, I don't think it's appropriate for the court to presume the government's theorized end result about how this happened and then look back at what happened at SUNY's and say that therefore there was conscious disregard. And I think that's what the Commonwealth is asking the court to do. Now, in terms of the reducing the verdict or granting a new trial, even if we assume for purposes of discussion that there was sufficient evidence of non-aggravated kidnapping and conscious disregard, a reduction to second-degree murder as the Commonwealth desires would not be appropriate in this case. And that's because, again, we have no assurance that the jury reached the essential elements of non-aggravated kidnapping. And again, as we've discussed, where the jury found aggravated kidnapping based upon this assertion that there was a gun involved when they left SUNY's, they would not have had to reach and would not have reached the elements of
as you phrase it,
kidnapping.
excuse me, as you phrase it, non-aggravated kidnapping, is that really just kidnapping?
Yes, Your Honor. I
Okay,
think
and
that
so is kidnapping a lesser included of aggravated kidnapping?
Well, aggravated it requires a gun. And yes, I think it would be a lesser included. And again, it would be a lesser included, but if they found aggravated kidnapping based upon the notion that there was a gun involved, they would not have reached the elements of non-aggravated kidnapping. And Your Honor, one point I should probably correct myself. I think that it is not necessarily a lesser included because.
Oh yeah, I guess you're going to explain that because that makes
Yes.
absolute sense to me if it's a lesser included.
Right, because we have the element of conscious disregard for the risk to human life.
That takes into account obviously the felony murder.
Right, and that's right. So it is a lesser included, but in this case, because we're dealing with a felony murder judgment and nothing else, then it's not lesser included, and that's why they would not have reached that element.
Well, it's a different element they have to satisfy for felony.
That's
murder.
correct. That's correct. And so I think we can also look at this and say that even if they did reach those elements, the judge's incorrect instruction obviated any evaluation of conscious disregard for the risk to human life because the judge told the jury that they could find that a non-aggravated kidnapping was inherently dangerous. And then he actually, in the same instruction, said that it was inherently dangerous through his instruction. So again, that's another reason that the jury would not have reached non-aggravated kidnapping as the predicate.
Did the instructor was inherently dangerous, or did he say you have to find it was inherently dangerous? Because he inappropriately, when it's inherently dangerous, as you argue and as you all know, the judge just says, I'll tell you, armed robbery, that's the classic, is inherently dangerous, and you take that away from the jury. Here, the inherently dangerous doesn't come in, but the judge improperly instructs you can either find conscious disregard or inherent dangerousness, correct? So he didn't tell them they had to do that. He gave it to them as an option.
Well, Your Honor, he did two things. First, as you indicate, he gave an instruction which gave them the alternative. Right. You can find it inherently dangerous. Then later on, he says that all the elements are the same as for first-degree felony murder, which in essence, as I indicate in my brief, if those elements were the same, then it was inherently dangerous. So by his referring to his instruction on first-degree felony murder, he's actually telling the jury that that this is an inherently dangerous felony. And so, in fact, he was doing both.
Okay, right. I
he was doing both, and it was contradictory. In addition to that, the judge omitted the instruction requiring the element of intent to secretly confine or imprison when leaving SUNY's. And that was obviously of great import because in this case, we have the Commonwealth who was relegated to asserting essentially that this was forced because there was subjective fear within Harkins. Now, closely related to the issues of sufficiency is the delayed return of death issue. And I say closely related because death is an essential element, and it was disputed in this case throughout the trial. And as the court knows, in this case, we do not have evidence of a body. We don't have direct evidence of an event causing death, and we don't have any forensics. And there are two problems that arise. The first is that we have what appears to be a calculated unfair surprise in the middle of trial and in front of the jury. The prosecution having completely failed to disclose the delayed return of death to the defense at all. And then the second problem is the government is presenting a piece of paper certifying that Harkins is dead without presenting a witness in violation of Mr. Trotto's confrontation rights. And this piece of paper represented the outcome of another legal proceeding that Mr. Trotto had no notice of and had no participation in. And I think it's noteworthy that contrary to the Commonwealth's assertions, this was not a certificate of death that was created in compliance with Chapter 46, Section 19, based upon the personal knowledge of somebody who was directly involved, such as a medical examiner. And it wasn't something that was recorded by an authorized individual under Chapter 46, Section 9. And I think the unfair prejudice here is quite obvious. By admitting this, it's telling the jury that another court of law determined that yes, Mr. Harkins is dead and the Commonwealth has met its burden. This same issue, the disputed issue concerning death, also arises relative to the Fusion Center database testimony.
Was that in response to Bowden challenges, Mr. Shaw?
The Fusion Center testimony?
Right. Yeah. What did you do? And this is what we did type evidence?
Your Honor, I do believe that that's the reason that the judge allowed it in, but I don't believe that there was a valid basis to let it in under Bowden. I do not believe, and I don't believe that the record establishes that this was admitted because the Commonwealth wanted to address how investigators made certain decisions about the case. I think that doesn't even make any sense at all. And in fact, if you look at the Commonwealth—
Was that subject to an I'm sorry, I forget from the record. Was that subject to an objection, Mr. Shaw? And if so, did the judge make a ruling that it was properly admitted to rebut a Bowden argument?
Yes, the judge did, and I believe it was objected to. And that was the basis that the judge allowed it in. My recollection of the record is that this really was sort of coming from the judge even more than the Commonwealth. But I don't think there was a proper basis to let it in for that reason. And I don't think it was limited. And Ms. Nystrom, she's an employee of the state police. She is assisting with the criminal investigation on behalf of the prosecution. She testified about database searches that she didn't conduct and results that she didn't acquire. She said somebody else in her agency did. And none of this was the product of documentation that was provided to the defense. So we don't have any meaningful information about these undisclosed databases or the third parties that ran and maintained them. And then we actually have Ms. Nystrom, who was testifying about internet searches that were conducted. And so I think the issue here is that really is a violation of the right of confrontation. The materials that she relied on for her testimony really insulated her testimony and made it untouchable. There was no way to probe it. There was no way to get at it. If there are no questions on that, moving on to the hearsay statements of Mr. Harkins. These obviously played a significant role in the case relative to the issues of force. And I think the first problem we have with all of these statements that came in is that the judge did not always provide a contemporaneous instruction. And when he did, he told the jury that they could use the statements not only for Harkins' state of mind, but on the issue of force.
This is under that whole very tricky McGraw exception, correct?
That's correct.
Where you have to prove the defendant would have known about it. Did the judge take that into account to make those findings?
I don't believe he did, Your Honor. I don't believe he took it into account at all. That's my recollection of the record. And I think the other problem that we have in addition to not offering contemporaneous limiting instructions is that the judge never told the jury that they could not consider the truth of the matter contained in the statements. So in effect, what this instruction was saying is that you can use the fact of these statements and their content, but you just need to limit it to these two issues, which are state of mind and the issue of force. And so that was extremely prejudicial because of the statements that came in. And that leads to the third point, which is that the unfair prejudice clearly outweighed probative value here. Even if we assume that Harkins' state of mind was relevant and admissible, at most, that should have resulted in general observations that he was afraid and that perhaps he said so, but in that general form, it should have been strictly limited to his state of mind and nothing more. But what happened is that the judge allowed in an excessive number of statements that included Harkins' belief that Trotto was going to kill him. Trotto was going to come after him.
Were any of these known by the defendant?
No, I don't believe that any of these were known by the defendant at all. He was even saying, that Trotto is crazy. There were even statements about Trotto being crazy and he'll kill people. So when you look at the McGraw case and you look at the Sire case, I think that both of those cases were homicide cases where the court reversed the judgments. And I think that the statements in this case are far worse. I also think it's noteworthy that there were statements about Harkins going to testify falsely in the Fredette matter. And, to say that he was the informant and he lied. And I think that that entire scheme was grounded entirely in these statements.
Attorney Shaw, I'm going to ask you to wrap it up. I know there's a lot of issues in this case, but if you want to just take a minute or two to wrap up.
Sure. I think I'll just wrap up by addressing the Carlos statement because that's something that Justice Gaziano was interested in. And what I would ask the court to do is look closely at the issue involving the prosecutor eliciting Detective Sergeant, from Detective Sergeant, these alleged testimonial statements from Carlo.
You want us to, from your brief, you want us to look at the grand jury transcripts to see if they were just one-word affirmations, correct? That's the right, Your Honor. So I think that there are issues about the grand jury testimony, and leading questions, and coercion, and so forth. Because the judge made findings, I think they were well supported about feigning lack of memory. I mean,
and I think
you have a tough road to hoe on those grounds, but a good argument, I think, on whether or not the grand jury was as fulsome as it need be.
Right, and I think that if the court would look, those are the first sets of issues, but then there's this second issue, which I would ask the court to really focus on, which I think is most significant, and that is the prosecutor eliciting from Detective Sergeant alleged testimonial statements from Carlo to other detectives, and then eliciting the fact that all of the questions asked of Sergeant when interviewing Trotto were based on those statements. And I think that was clearly error. And the reason it was so significant in this case is that the prosecutor did it in order to rehabilitate Carlo's testimony, because I think Carlo's testimony before the grand jury and his testimony at trial needed to be, it was challenged competently. I don't think it was very persuasive. And so eliciting these additional testimonial statements was highly prejudicial to Mr. Trotto, and I think clearly improper.
Thank you.
Thank you.
Attorney Lazar.
Thank you. Good morning. Ellen Lazar for the Commonwealth. As the defendant noted, the Commonwealth concedes that the first-degree murder conviction cannot stand because the predicate felony of aggravated kidnapping did not exist at the time of the crime. And so the Commonwealth asked the court to reduce the conviction to second-degree murder. It's the Commonwealth's position that the record supports a second-degree felony murder conviction. Given the verdict at the defendant's trial, the jury necessarily determined that the defendant kidnapped the victim and that the victim's death occurred during the commission.
A few issues to discuss, Ms. Lazar. First is the McGraw issues.
Yes.
Were the necessary findings made? Because that's a very complicated area of our law that allows prejudicial information to come in, and it's cabined, of course, as you know, in McGraw. Were all those necessary findings made by the judge that the defendant knew about the statements or likely knew about the statements?
Well, Your Honor, I actually disagree that that's necessary under the McGraw line of cases.
I was going to ask you if I've got that right as well. So
yes,
please.
I don't believe so. I think there are sort of two lines of cases about when statements expressing fear are allowed to be admitted. Under one of those lines of cases, there's a requirement that the defendant knew about how the victim felt or what the victim might have said, and that.
Well, I'm going to leave him, and then the husband knows about it.
Right, such that the defendant would have acted on those words.
Right.
But under the McGraw line of cases, there's actually not a requirement that the defendant knew about the statements and would have acted on them. Instead, under McGraw, it's that the defendant sort of opens the door to statements made by the victim if the defendant claims that the victim would have voluntarily been alone with the defendant or other circumstances. If the defendant, let's say, claims that the victim committed suicide, but obviously that doesn't apply here. So here, the statements were admitted because the defendant claimed that the victim voluntarily went with the three co-defendants to the car. And so the statements were admitted with an explicit limitation that they were only relevant to the victim's state of mind as it pertained to the issues of force and whether.
So to rebut that they were all good friends, you were able to put in victims' statements, prior statements that he was afraid of defendant.
Right, to rebut that he voluntarily entered the car. And the judge very explicitly limited the statements, both at the time that they were admitted. I think he gave at least 4 contemporaneous limiting instructions, and then he also gave a limiting instruction in the final jury charge saying, you have heard statements that Kevin Harkins expressed fear. Obviously that's a summation of what he said, but that those statements are strictly limited to your consideration as to what the victim's state of mind was as it pertains to the issue of whether he voluntarily entered the car, and that you may not use those statements for any other purpose.
Can you clarify for me what exactly the testimony was of Mr. Carlo admitted substantively as far as a gun, no gun in the car?
Yes, I think it's at transcript 6, I believe pages 80 to 85 is the testimony that was admitted substantively after the voir dire and after Judge Tucker's findings. And I don't believe that within that testimony there was anything about a beating occurring. I believe that he said
that was in the other case then. I'm
Well,
confusing
that
that.
was definitely in the other case, and then I was trying to recall, but can't recall right now, whether it may have come out earlier in this trial during the initial questioning of Mr. Carlo, which when he was essentially a hostile witness and the judge was allowing the prosecutor to lead him. But the part that came in substantively after the judge made his findings was that the defendant said that they had a beef with Harkins because he had set up John Fredette, that they picked him up at SUNY's, both along with Fredette and Samia, and that the defendant said that the gun went off and he shot Harkins before he wanted to, and that it went off accidentally while he was holding it, and that when it went off, blood went everywhere.
Okay, so that leads to what Mr. Shaw argues, it was insufficient evidence of a kidnapping. Where do we get evidence of either a kidnapping or conscious disregard?
I think that the evidence was sufficient to support kidnapping and that the victim was forcibly confined or imprisoned by the defendants against his will. The
When?
jury heard from multiple witnesses that the victim
when
was...
when did that happen?
When did they hear?
No, when, I'm sorry, when was he forcibly confined?
Oh, I believe when he was actually led out of the bar across the street with the defendant walking what was described as 6 inches behind him. And then the victim went to get in the back seat of the car and was essentially ushered into the front seat of the car by the defendant, who then the victim gets in the car and the defendant gets in right beside him. So now the victim is sitting between 2 of the co-defendants in the front seat of the car. And then in addition, there was this evidence that the defendant had a gun at some point during all of these events, which went off before he intended it to.
Where do you get that evidence? From Carlo?
Yes. Yes, that's from the statement that he made to Carlo. And there was also evidence that Samia's girlfriend testified that he always carried a gun except when he was at family events. And in addition to that, several hours later, when Samia and Fredette are stopped in Samia's car, there's blood in the car, on the seat, on the floor, on the door jamb, and then on the back of Fredette's coat and the front of his shirt. So all of this evidence taken together, it's the Commonwealth's position, supports a finding of kidnapping and also supports a finding that the crime was committed with conscious disregard for the risk of human life, that these 3 co-defendants kidnapped the victim with a gun in this small confined space, having this motive or this, anger towards him, as he described it, a beef. And I would point the court's attention to Commonwealth versus Ortiz, which is a case where the court found that a kidnapping or a crime was committed with conscious disregard for human life, where the defendants drove around in a car with a loaded gun looking for a person that they had a long-standing feud with. So in this case, where the jury found that the defendants kidnapped the victim, 3 of them in a car with a gun, and again, blood in the car found later, and the jury did also find that they committed serious bodily injury upon the victim, that all of this supports a finding of conscious disregard to human life.
I'm sorry, that might be the all questions I have for now.
Okay. As to the delayed return of death certificate, the trial judge correctly exercised his discretion to admit the certificate under Chapter 46, Section 19, which provides that the record of the town clerk relative to a birth, marriage, or death shall be prima facie evidence and shall be admissible. This was a record of a town clerk relative to a death. It fit the precise terms of the statute. The judge offered to redact out any of the information on the certificate if the defendant wanted him to, offered to give an instruction the defendant.
We used to, as you well know, have a statute that allowed for the admission of drug certificates. And then the Supreme Court told us in Melendez-Diaz that it was unconstitutional. What do you say about that?
I would say that those certificates were testimonial because they were explicitly created for the purpose of the litigation, whereas this certificate was not created for the purpose of this trial. This is more akin to a death certificate. It showed that someone died. It's true that it was issued 7 years later after a probate court proceeding, but it was not created for the purpose of this trial. And as a public record, a more traditional public record, it's the Commonwealth's position that it was not testimonial. I would also argue that if the court were to find that there was any error in admitting that certificate, it was harmless because the evidence that the victim died on the night that he was last seen with the defendants was really overwhelming. At least 9 witnesses who were close to the victim, friends and family, and his employer never saw him again after the moment that he walked out the door with the defendant. He left all of his belongings on the bar, half a beer, his pack of cigarettes, his favorite coat, his keys to his apartment, suggesting that he believed he would be coming back. The defendant again admitted to having shot the victim and dumped his body. And Sammy and Fredette were stopped a few hours later with blood on them and in their car. That car was destroyed later on the very same day, even though Sammy had only bought it a couple of months before. And in addition, in the defendant's statement to the police, he claimed essentially not to have even known the victim and said, oh, what was his name? Hawkins? And he also said that he really didn't frequent Suni's pub. And there was evidence from multiple witnesses that he used to see the victim approximately twice a week. So the victim could buy drugs from him and that he was in Suni's, all the time. So the jury could have considered that too as consciousness of guilt. So,
on the feigned memory issue on Mr. Carlo?
Yes.
There's a lot of one-word answers in the grand jury, correct? Isn't that a problem for you?
I don't believe that there actually were one-word answers, Your Honor. First, Judge Tucker clearly was aware of the requirement that the answers not simply be agreement with a leading question by the prosecutor, and he did admit the testimony with that caveat. And the judge noted that there may be situations where a leading question was asked where the witness said yes or no, but then there was sort of a follow-up where the witness then more fleshed out the answer. And so if you look at the questions and answers that were admitted, which were chosen carefully, the prosecutor didn't just go through all of the testimony. He went from, line this to line that. There were places where he may have said to Mr. Carlo, isn't it true you said this? And Mr. Carlo might have said, well, something along those lines. And so the prosecutor says, well, okay, so what do you mean by that? If you didn't say exactly that, and Carlo says, well, what I said was. So if you look at all of it in combination, it is in Carlo's own words, even if the initial question is sort of a predicate, that Carlo later fleshes it out in his own words. If the court has no further questions, I would just rest on my brief.
Okay, thank you very much, counsel.
Thank you.